cyclical issue here that kind of pops up. So
yeah, well, I have been talking about it mostly to myself and a few select people for 2 years, and now I'm so happy that it is so much more fun to have the entire kind of world in on kind of the conversation. And so it's been lovely for the past week.
Wonderful. So it is now 6:05 Israel time, and I'm very pleased on behalf of the Feldman Center and the Haifa Center for Cyber Law and Policy to kick off our annual conference, jointly held. We will hear today 2 panels, and we will hear tomorrow 2 panels. My co-coordinator, Professor Yuval Shani from the Hebrew University in Jerusalem, and myself are very pleased to have you here. We would like to extend our gratitude to our speakers, both today and tomorrow. I will be hosting the first session today. The second session today will be led by Dalit, Ken-Dror, Feldman, also from Haifa. And without further ado, and of course, I'd like to extend our gratitude to Tal and Lily, the coordinators of the 2 centers. Without further ado, I'd like to start our first panel because time is short. We sort of condensed the conversation today and tomorrow. And we have with us Meir Levin, who is the Deputy Attorney General in Israel, in charge of all matters technological, that is of the regulation of technology. And then we have Professor Niva Elkin-Koren, who used to be from Haifa, but is now in Tel Aviv, and Dr. Karni Chagal currently from Ottawa, but she told us she's now physically in Montreal. To address the situation perhaps from the market or from private law. So Meir, please, I understand. I'd like to especially recognize Meir because, as you might have heard from the news, there are things going on in Israel right now, and at his level of seniority, there are other things on his desk as we speak, and he was willing not to let everything else go for the moment, for the duration of his talk. And then to address us. So we've really appreciated. Meir, the floor is yours.
Thank you very much, Amnon. And hi, everyone, and thank you for having me here with you today. It's a great pleasure to attend this conference with such esteemed guests and on such an important topic. I would say that the repeat changes in technology and the business environment set new and unfamiliar challenges for regulators and government lawyers. This will require us to rethink or reshape familiar concepts and legal doctrines. And as we wander into these uncharted territories, we will need partners who can help us develop the much needed critical and creative thinking on these matters. I believe that the academia can be such a partner, and therefore I'm very grateful for the cooperation with Professor Reichman and the center. I will try to present to you today the dilemma that the government is facing when it comes to regulation of technology. These dilemmas are universal in their nature, but I will try to address them from an Israeli perspective. According to Jewish tradition, there are times when we are required to shev ve'al ta'aseh, which means sit and do not do, or sit and do not act. However, there are times when we are instructed to do the complete opposite, kum ve'aseh, meaning get up and do, or rise and act. When we are not certain which rules apply, the tradition supplies us with a thumb rule. When in doubt, choose the former, sit and do not act. When it comes to innovation, regulators and legal counsels are facing a similar dilemma. Should they sit and not act, or should they rise and regulate or supervise? This dilemma is universal, of course, and many governments are contemplating when and to what extent they need to interfere with innovative technologies. I believe that in Israel, the startup nation, this dilemma is even more salient. This is due partly to the role that the high-tech sector plays in our economy. It is one of Israel's most productive industries and has a significant contribution to our economy. Just to give you an idea, according to a report by the Innovation Authority, 24% of all of Israel's income taxes are from this sector. In these circumstances, you can see how the government can be unwilling to interfere and why policymakers are attentive to claims from leaders of this industry. Their preference is that the government's involvement would concentrate on grants and tax relief to stimulate the tech sector as the main engine of the Israeli economy. Other claims against government interference argue that it would be wrong or impossible to create regulation at the state level. First, as technology knows, its regulation should be a matter of international cooperation, for example, within the EU or the UN. There is also a concern that fragmentation of the regulation may lead to a race to the bottom, as we experienced with corporate tax. Second, many of the startups operating in Israel are not targeting the Israeli market for the products or services. They are interested in the regulation overseas, in the US or the EU. Therefore, local regulation may be irrelevant for them, or worse, may drive them out of the country. Personally, I do not think that the conclusion is necessarily that Israeli regulators should just sit and wait for the developments from overseas. After all, regulators and government lawyers must take into account considerations or values other than the general need to maintain Israel's lead position in the global arena. Obviously, there are opportunities and risks that should be carefully evaluated. Autonomous vehicles provide us with an interesting case study. In this case, Israel has the opportunity to compete with other countries and attract companies to operate in Israel. A major company in the field is already located here. We have skillful engineers, the insurance regime is favorable, and apparently so is the weather. Indeed, we are talking only about the experimentation stage, but even that can bear great benefits to Israel, strengthening the technological ecosystem and providing transportation solutions. These benefits cannot be materialized if we choose the option of sit and do not do, as the current regulation practically blocks the option for large trials of highly autonomous vehicles. If we just wait for international developments, we may lose Israel's edge in attracting companies to operate here. On the other hand, allowing vast experiments is an adventure that bears significant risks for safety of road users. Therefore, simply waiving regulation with no safeguards for the public is not a viable option. So even if we choose the option of rise and act, it is not sufficient to just remove all barriers to the deployment of these vehicles. In my opinion, large trials require us to actively design appropriate regulation, even if Israel is not experienced with designing regulation or standards for auto industry, as we usually rely on foreign regulation for this. It is worth mentioning that political instability in Israel plays a significant role as well. In the last 2 years, it was extremely difficult to promote legislation in the parliament. So by default, we are choosing the sit and do not act option, risking that companies that are considering Israel will become impatient. Another example is the regulation of local activity of international media companies such as Netflix, whose broadcasting over the internet may exclude them from the current regulation. This case provides another example of the dilemma of sit and do not act or rise and act. Some countries demand that international media companies invest in local production like any other local broadcast company. Countries with large markets, such as Italy or France, may be able to impose that requirement because it coincides with Netflix's interest to create local demand. Such regulation exists in Israel for local broadcasters. However, trying to impose it on international companies may just mean that they'll ignore the small Israeli market and avoid entering it altogether. After all, not all Israeli TV series are as popular as Fauda. The middle way between sit and do not act and rise and act might just be the sandbox option that allows for regulatory experiments. This widely adopted framework for fintech companies can allow us to rise and act, but on a small scale and on a temporary basis. Building on the results of these experiments, we can learn whether it is preferable to sit and not act or rise and act, but in a more evidence-based manner. This is why my department in the Ministry of Justice is actively considering promoting a general sandbox in the Israeli law. I would like to conclude with the wise insights from the book of Professor Lawrence Lessig, Code is Law. Technology is hardly neutral. It will always embed a balance between different values. There is no regulatory void when it comes to technology. The question is who will regulate the technology and determine the balance, the engineer, the product manager, or the regulator who represents the public interest. Therefore, even if sometimes we choose sit and not act, we should always remember that others are rising and acting in ways that we do not always approve. This is in a nutshell the dilemma that we are facing daily. I really apologize for not being able to stay here for the rest of the speakers due to the security situation, but it's only my loss. So thank you very, very much.
Thank you, Meir, very much for your words. I take it that you can, would you like to take a couple of, you know what, maybe we'll hear from Niva and Karni. I understand that Yuval might stay here and also reply, unless you want to take a couple of questions now.
I'm waiting for a phone call, so Yuval and Sarit are here, and they will give better answers than me. So you're in good hands, don't worry.
Okay.
We're staying here.
Okay, perfect. So we've just heard the concluding remarks of Meir Levin, where that there is no regulatory void. Somebody always regulates. And with that in mind, we turn to Niva and Karni, who can tell us about different modes of quote unquote regulation that are not necessarily state-based in the traditional sense. So Niva and Karni, the floor is yours.
So let me just put the right slide. That would be a challenge. Can you see it?
Yes.
Great. So before you introduced us, I meant to say, in the spirit of Monty Python, now to something completely different. And it is completely different in the sense that what we are going to present and discuss now is a theoretical paper. It's a paper that is focusing on types of governance. It is linked to some extent to what Amit Levin was talking about, and that is a need to examine and maybe reconsider some of the regulatory conceptual frameworks. And so within this spirit, we actually wrote this paper, which in fact revisits a paper that was published by Professor Joel Reidenberg, one of the legendary cyber law scholars who passed away last year. And one of Reidenberg's claim to fame was his seminal paper on Lex Informatica, where he actually observed the rise of regulation by design, describing how affordances of design and choice not only embed values, but also actually regulate or could regulate the behavior of people. Amit Levin also mentioned Professor Larry Lessig, which of course coined this approach, code as law, and also developed a whole framework of studying not just the effect of design, but the interconnection between design, social norms, market power, and legal norms, focusing on the interconnection between them. But both Reidenberg and Lessig actually focus on rule-based algorithms. And the question that we tackle in this particular paper is whether the insights which were appropriate for rule-based algorithms and the nature as a governing tool also fit what we called in the spirit of Reidenberg, not Lex Informatica, but Lex AI. In a nutshell, to start from the end, we are all tense about the security situation. Maybe we won't have time to finish this talk. In a nutshell, what we are arguing is that Lex AI doesn't fit neatly within the public-private ordering distinction. And not only that, but it also suffers from disadvantages on both levels. As private ordering, it fails to reflect the choice of the governed, and as public ordering, it lacks participatory and deliberative space for processing and negotiating the values, which is a space that is necessary to gain legitimacy under public law. So let me start with just presenting the background for Lex Informatica. And so Reidenberg in Lex Informatica was actually puzzled by the introduction of the internet, a global net that enabled people to communicate and exchange content across national borders. That created a problem which was puzzling for not only for Reidenberg, but for many of the scholars during the 90s, and that is how to bridge upon the different speech norms that would apply to people who are posting the materials and people who are consuming or reading the materials, so that something that could be legitimate or considered legitimate in the jurisdiction where the author of the content, the distributed content reside, would be illegitimate or illegal in the jurisdiction where it is read. And Reidenberg saw a solution in design, and in more particularly in this particular design, and that was a platform called PIX, Platform for Internet Content Selection, that was developed by the World Wide Web Consortium, which enabled the neutral labeling of content. And so this was a neutral standard that enabled labeling by different stakeholders. That could be the publisher of the content, the different consumer, different NGOs, users groups, or the consumer of the content herself. And what was really interesting about this neutral standard, that was the multiplicity of options. It enabled users to label content both by dimensions that they would choose, like obscene, violence, or anything else, right? If it's religious content, right? And also the scale, whether it's little obscene, it's very violent, and they could choose between 1 and 3 or 1 and 9, or whatever scale they choose. So this was really open in terms of the norms and speech values that it enabled. It was rule-based in the sense that a filter could identify it, that was worked on if-then rule, right? If I design my filter on non-violent content, and content is labeled as violent, like if I wanted less than 3, and the content was labeled more than 3, like 4, then my filter would filter it out. And the speech norms that were enabled by this type of design, of course, address the problem that was challenging for scholars in the 90s. That was the difference in speech norms across jurisdictions, by enabling the customization of speech norms and the selection of the speech norms that would fit your own preferences. Of course, nowadays we are no longer challenged by this problem because digital platforms have created some sort of harmonization, and to the extent that they differentiate between jurisdictions, they also do it in a harmonized way. I am sure that we will hear more about it in the next session, and that of course raised major concerns regarding the enormous power that is entertained by these digital platforms. But our focus in this paper is not on the who is doing the content moderation or the shaping of speech norms, but on how it is done. And we are focusing on the example of speech norms in order to try and understand if there anything that is special about the way Lex AI is governing norms. So is there anything important to learn as we move from content moderation that was done by algorithm to content moderation that is done by learning algorithms that are driven by data, and how does it affect our the classification of this type of decision-making process as private ordering? And for those of us lawyers, that of course affect the way in which we would also describe the role of the of government, the role of law, the scope of legal intervention. This type of exercise is the type of exercise that we are accustomed to do with markets. So in markets, we know how markets decide. We know that the market decides by the price, that the price is signaling some sort of preferences, and it is mitigating supply and demand. We know when it does not work, right? We know how to identify market failures, and that is where we think that governments could intervene. And the question is whether we can think we can run a similar analysis as we look at the decision-making process that is facilitated by Lex AI. And as I've said, the example that we have chosen is the example of speech governance. And speech governance is an interesting example because it actually enables us to look at two different types of case studies. One is enforcement of norms, that is, the norms are actually decided by the state or the government, what is allowed and not allowed, and the Lex AI is only enforcing a norm that was already decided somewhere else. And then speech governance by AI is also taking place where some systems, especially in content moderation and in the creative role of platforms, is actually deciding what type of content will be accessible to us, and that is through the recommendation system or the editing of our feed, etc. And so if we start with the use of Lex AI and enforcement, that is a pretty simple process. So we have something that is equivalent to the labeling of that we've seen in Lex Informatica, where we actually have to decide or to identify technically the type of content that has to be removed. So that could be hashtags of terrorist propaganda, that could be content ID that would identify infringing materials. And this could be provided by governments that want to tackle terrorist inciting materials, or by right holders that want to filter out infringing materials. The system will be trained to identify these hashtags or these signals. So every time we have a new clip or a new type of content that is being fed into the system would have to make a decision of whether this remains or this is being filtered out because there is a match with the hashtag or the content ID. And what is really interesting and differentiate this process from the process that we've seen in Lex Informatica is that this type of system would have a feedback loop so that the system would learn to next time to identify content or similar content. Or in other words, the more the system would practice certain type of content to be filtered, the better the system will get in filtering out that type of content. That is the learning process of the system. We see something similar that is happening when we think about the recommendation system, like content moderation for the purpose of curation. How our recommendation list on YouTube is being built, or how our feed is being designed by Facebook, and that is pretty much the same, though there is a collection of data that is being processed by the model that would decide what it is what type of clips, let's say on YouTube, that are being offered to us. And then once we click on the YouTube clip, then the system would learn to classify us better, so the better will get a more accurate or more personalized, tailored to us type of selection. And so the question is, how do we think about these systems in the classic classification between public ordering and private ordering? And when we think about it in terms of private ordering, one could think that this is actually a more efficient way of doing customization, so that if customization before was supposed to be by the user and they had to invest a lot of effort in classifying and labeling, and this was not that efficient and accurate, what we have now is a type of more efficient personalization that can actually, without us making too much effort, personalize the content for us. But rather than doing the having the choice made by the user in personalization, what we see is a process that is actually determining for the user what their predicted choice or predicted preference would be. And as we've learned, from the literature, that is something that is very difficult to divert from. And personalization not only is not based on the choice of the user, but choice made for the user, but it is also a reflection of an optimization function that often would reflect some other values in its design. So let me turn it now to Karni to walk us through these two aspects of choice and the optimization function. Karni?
Sorry, I was on mute. Thank you very much, Niva. And I'll start by saying that after a year in Canada, my English should have been very fluent, but I've been sitting at home during this year, and I'm in Montreal, so if I go out to the street, people yell at me for not speaking French. So I will surely get stuck. If I do, please humor me. So as Niva said, the personalization feature of Lex AI, it intuitively tempts us to think that, well, even though if it doesn't reflect active choice by the user, by the individual, it knows what we want, it knows what we need, and it could reach not only more efficient results, but even legitimate results as in private ordering, because it does what we want and what we choose. And in fact, this is not the case. the efficiency and legitimacy advantages of private ordering, they rely on the assumptions that a user can make informed choices. I mean, not just sort of arbitrary choices or pure luck, but they know what the choice they're choosing entails, that they in fact can make the choice themselves, and that their choice actually reflects their true preferences. And we say that with Lex AI, this is not necessarily the case. First of all, obviously, there are those AI systems who offer no choice whatsoever. A prisoner subject to the compass system, for example, does not choose to use the system, nor any of the choices it allows are not made by him. Also, those systems who are voluntary, sometimes you don't really have a choice but to use them. If I want to apply for a certain job, a unique job, and the only HR process is through an AI system, I do not really have a choice not to use it. But we're putting this aside. We're even talking about those systems who are voluntary, who people can choose to use them or not to use them. And we can even talk about those AI systems that offer active choice. For example, if there is an AI system where I could say that I want to filter violent content. I don't want my kids to see violent content, and the system, based on what it knows about me and my habits and my household, and my past preferences, would tailor-made its filtering choices, especially for me. But in fact, when I'm making the choice to filter violent content, it's not an informed choice as of a person under Lex Informatica. One of the examples that Professor Reidenberg gave is that of the system where pre-classified content could be filtered or not. I would not have control over which content to classify as violent or not, but I would know how it is classified. And then when I choose to filter violent content, I more or less know which content will be allowed and which will not. Whereas in Lex AI, if I choose to filter violent content, then in many cases, I do not know what I get. I do not know what type of content will be filtered or not. Why? Because the process of the deciding which content to filter is based on an enormous amount of information that is dynamic and changes all the time, and not even the designer of the system know all the time what result it would lead to. So in these terms, the user's ability to make informed choices is more limited. But also, in fact, we cannot necessarily say that they make the choice themselves. In that sense, well, obviously, if I use Waze and Waze tell me to go left, I can say, oh, no, I will not go left. But all the instances we saw of people going over a cliff or entering a hostile zone because they did what Waze told them, show us what is called in the literature is the nudge or super nudge effect, where the system tells you to do something, often you listen to it. Even if you chose to click yes or to go left, but it's really affected by cognitive limitations. Even those systems who do not tell you go left, but give you 4 options to choose from. The fact that they gave you those 4 options and not other options mean that most people will likely not bother to look into the 5th option that the system did not propose to them. So even if we actively make a choice, it could be said that this choice is limited. Lastly, and maybe even most importantly, we perhaps could have said, okay, it doesn't reflect a true active choice, but if the system is so smart and it could collect information, tons of information, first of all, but also information that perhaps we don't even, are not even aware about or don't remember or do not know that are relevant, and can therefore make better decisions for us that truly reflect our preferences, maybe even though it's the system and not us. Maybe not only it's more efficient, but it's more legitimate. Who of us would not want, to a world where everything you want is immediately executed? I guess it depends on who those people are. But the thing is that these systems do not, or only to a limited extent, reflect the true preferences of people. And why is that? First of all, and we said we would not talk about the who, and we will not talk about the who, but these systems are operated by various stakeholders for various reasons. And I think it's safe to say that the vast majority of them are not designed to maximize the preferences of individuals. They may say they do it, they may do it as part of other type of functions they're maximizing, commercial functions of the manufacturer, or other functions of the parties using them, but not necessarily the preferences of the users. And this is one thing. Second thing, I'll talk about it when I give the example. And the third thing is, these systems, when they tell us what our preferences are, they don't really know our preferences. They make predictions, and these predictions are based on many things, but two main things: my past preferences or past behavior and features, and the preferences of others. The system makes predictions based on statistics on how similar the current underlying situation is to other 10 billion similar situations. If I want to watch a comedy and I also watched science fiction movie last night, then I'm similar to 10 million other users who did the same, and then I will probably like the recommendations that they have chosen from. But the problem is, first of all, it relies on past preferences, even if my own. My current preferences might be different than my past preferences. But because of the feedback loop that Niva explained about, past choices and past behaviors are recursively fed into the system and affect my current choices. Affect the current choices the system makes for me, even if they do not reflect my current preferences. And moreover, the system not only reflects past behavior and not necessarily current behavior, it also limits my ability to change my preferences. Because if for example, I want to try new things. I've watched comedies my entire life. Now I all of a sudden want to try documentary films. The system recommending movies for me will probably not let me, because it will not expect me to want to change my preferences. So this is one aspect. And also the second thing is that the system is based on the preferences of others, not me. And one of the implications is that the choices the system makes for me could be changed based on the preferences of others, even if it has nothing to do with my own preferences. If I remain to the example of movies, which I really am waiting for the entire cinema world to return back to normal. For example, I say that I do not want to watch violent movies, and the system has filtered a certain movie for me. Let's say that for reasons that do not relate to my own preferences, many users now think that a certain movie is not violent. And the system learns that this current movie is not violent based on their preferences. And then it chooses it for me, even though my preferences have not changed. I don't know if the explanation was clear, but the point is that the system will change its choices for me, even though my preferences have not changed, because the preferences of others have changed. And so the conclusion of this point is that not only does Lex AI limit or offer only limited extent choice of individuals, but it also does not probably, or usually, or many times, that does not truly reflect their preferences. And I will take the example of ways to lead us to the next point. On its face, Waze seem is a system that it's personalized, and it reflects my own preferences. I want to reach from point A to B the fastest way possible. And the system collects information about my current location and speed. And it could also be personalized in the way that it knows if I'm riding a car or a motorcycle. Perhaps it could also weigh in whether I usually drive faster or slower than average, and it could factor it in on the ETA. And we would think that if we look at Waze as a private ordering mechanism, we say, okay, for each individual, it maximizes its ability to reach from point A to B the fastest way. But even Waze is doing more than that. It also has a collective action element to it, because if, for example, a road is congested, then ways looking at the utility function of the collective, wanting to reduce congestion for everyone, it could start diverting certain cars, certain drivers, certain users to different roads, even if they're longer, to scatter traffic. And in that sense, they're not maximizing the preferences of each individual, but the collective as a whole. Moreover, and I said I will get to it when I give the example, it's interesting and it exists in all AI systems. The AI systems have an inherent trade-off between the will to maximize a certain function, let's say even the preferences of a user, to reach from point A to B the fastest way, and to also explore. Because if the system knows about 10 alternatives and it doesn't know about an additional 5 alternatives, for example, roads that have not been used for a long time, then the system has an inherent interest in, we would say, sacrificing some of its users in order to explore, in order to collect information for the system, so that later on the system could propose better, more efficient alternatives for its users. So in that sense, Waze is an example of a system who looks as private ordering, but in fact, as seen as the next slide, perhaps does the role of social engineering, being a centralized system that collects and aggregates data on individuals, but to maximize a collective function or goal. And we can go on to the next slide, which exemplifies the weird or hybrid nature of Lex AI, and it has certain aspects to it. The first is that whereas rule of law is, the legal system or democracies in general are done from a governance point of view, top down. The central ruler or sovereign decides for everyone. In private ordering, the main advantages is it's a bottom-up system that reflects individual own choices that they can decide for themselves. But Lex AI is neither, because on the one hand, as we've seen, it does collect information in a top-down, a bottom-up manner, which is individualized and personalized. But on the other hand, the system then uses it in a centralized manner that affects everyone. But here, we do not have a single ruler or sovereign making the decisions. We have a multiplicity of different stakeholders who operate these AI systems, who many times also interact with themselves and affect each and every one of themselves. So this is one aspect of, and I wouldn't say peculiarity, of uniqueness of Lex AI. And another two aspects that are related to each other are participation and deliberation, because the legitimacy of private ordering is the fact that they're driven by users' own choice or individuals' own choice. Under the rule of law, we of course, we know it, we do not make our own choices. It's the institutions who does, but we are involved. We can participate in either the election and voting for the ruler, in referendum, in public consultations, and in writing opinions and trying to make a difference. Whereas, as we've seen, the Lex AI, the participation by the individuals, it does not reflect choice. It's only passive participation where information is collected on us and used for us. This is coupled with the fact that the norms of Lex AI are opaque and are hidden, in that sense that under the rule of law, we have explicit norms. They could be subject to later interpretation by the court, so there is flexibility to them, but we have explicit norms. We have a process for deliberating them, of trying to balance between conflicting interests and having each interest taking into account. Under private ordering and Lex Informatica in particular, the norms are known in advance. It's an if and then situation. If you, I don't know, if you push this button, then something will happen. But under the rule of Lex AI, the way the norms are shaped are done by the black box algorithm. It's not open to discussion. It's not open to deliberation, and therefore, if you can see on the final slide, we are left with what we call a governance unicorn. It's not private ordering. It's not public or collective ordering, and it suffers. It has advantages naturally. We do not want to take that away from Lex AI, but it also raises challenges. And I think maybe we can talk about the challenges and potential solutions in the panel. But just one thing we could say, we've mentioned that there are many players whose play is now different because they take information on everyone, but use it to make centralized decisions, not by a single ruler, but by many stakeholders with different interests. Plus, a challenge we've also discussed about is how to amplify or try to give more room to users' choice, or at least to users' true preferences. Maybe, for example, by designing these systems such that there is more room for users to stop and make sure that this is what they want, or give in more of their input for the system's final choices that they make for them. So thank you for this.
Thank you very much. We've fascinating discussions. We've heard from Meir Levin on the idea of regulatory sandbox and the position of the state and how the state should think about what is regulation. We've heard from Niva and Karni about the regulatory functions of AI that are a unique case of a form of regulation that also regulates one's preferences in an indirect and opaque manner. I have a comment, and if anybody else would like to comment or say something, please either raise your digital hands or write something in the chat for us. I just want to reflect very briefly on the juxtaposition of those two interventions, and three concepts come to mind. The first is the concept of knowledge. Sometimes referred to as evidence or interpretation of evidence. The idea that Meir Levin stressed, is that right now, we are in the era of evidence-based regulation, or we expect the state to have the form of justification to its regulation that is not only value-based, but is also evidence-based in the sense that we want to know something that is akin to causation. We don't actually mean causation in the hard sense of causation, in the physical causation, but we'd like to know, for us to be able to deliberate, to understand, to make sure that our agents in the government actually work according to our values. What was the evidence? Now, the notion of knowledge was also reflected in what Niva and Karni said, and that is that we don't know. Not only do we not know who does it and in what way does it, the classic issue of opacity or opaqueness, but even our preferences, we don't necessarily know, in the sense that they're not necessarily our true preference. We don't know what the alternatives are necessarily, because we're not presented with alternatives. So we lack a crucial element of knowledge of where we are vis-a-vis the available choices. There's something to do with knowledge or evidence that is tricky with respect to AI, even though, again, paradoxically, AI should be the all-knowing. That's the idea of the AI. It knows. That's what, well, it knows. Related to that is the notion of agency and choice, right? So agency comes to mind. And agency, I think that it's interesting because I think Meir Levin also was careful with respect to the notion of agency, and that is not only providing regulation in such a way that empowers the agency of the regulated so they can make informed choices, and that also relates to what Karni was talking about in terms of informed decisions, but also the notion of agency in a way that is deeper than that, almost ontological, in the sense that if there's actually an element of choice, then it's more genuine in law. Not only in terms of the consequences, you won't be able really to anticipate, you don't know what results will happen. This is a consequentialist notion of, or instrumentalist notion of agency. But for us to be human, there has to be that which cannot be necessarily replicated by AI, or even more strongly, which AI may undermine in ways that are not necessarily. Now here, sandbox, the notion of a sandbox, in an interesting way correlates with what Karni has ended her presentation, because what is a sandbox from a perspective of, let's try something. And what was Karni saying? Give us choices so we can experiment. And if we shift this, what will happen with the AI? If we shift that, what will happen with the AI with respect to what we'll get, the choices we will get? So give us sandbox in a way, asking the AI, give us a certain sandbox where we can play around, knowing, because that's a notion of sandbox. Sandbox is a controlled environment whereby you play, but you continuously measure your informed decisions or quasi-informed decisions. So that's an interesting concept, the notion of, and the last is the notion of language that came to my mind at least. And that is AI speaks in a language, not only is it code-based language, it speaks in manipulative language, in the sense that it sort of tells you what you really want to hear in a language that doesn't necessarily allow you to distance yourself from the language in a way that, so it incorporates you into the language in a very peculiar way. And I think the state also has an issue when it comes to regulatory language, because the law communicates either rules or norms or standards. There is an inherent shortage, we call it, or limit of the legal language. We know that. This is why we need interpretation built into any law. And then the trick is, do we really need all this language? What AI offers us is get rid of the language, in the sense of tell us what you want, and then we will just shape or design something for you in ways that we know better how to communicate with you. This notion of you communicate, let us, we will. So this notion of language and how to talk about the notion of communicating with language is also, I think, part of the equation. Now, I've talked enough. Anybody else would like to comment, or maybe the panelists would like to comment on each other. Maybe Yuval or Sarit would like to comment on what Karni and Niva said, or vice versa. I open the floor.
Can I just quickly respond?
Sure,
I think
sure.
It's really interesting. I would knowledge, agency, and language. I know that we are very short in time, but I would just say that I definitely agree with your points about knowledge and agency, and especially thinking about the way in which Lex AI is a type of hyper nudge, and it's really taking, the concept of nudge even further than we've learned in behavioral law and economics. But I would actually, I guess I disagree with the issue of language. And the reason is that I think that the language of Lex AI is data, it's not code. And I think that is where the difference is. That is what is making it significantly different in the way that actually Karni explained, because it keeps us apart, but also calculate us together in ways that are not transparent to us and not comprehensive to us. That is why we do it by machine learning. And when we people, and that is why it goes back to agency and knowledge, we are accustomed to be governed by norms through their communicative power of communicating to us what are the values, what are the objectives, what is allowed and not allowed, legitimate and illegitimate. And we don't have the same properties in governance by Lex AI that is driven by data.
I share. Okay, so maybe I thank you for the refinement, because what I actually meant was that AI language is a different type of language that we're used to. So if we talk about communicative systems, and how to deliberate whether you are in a deliberative democracy, elitist democracy, or pluralist democracy, doesn't really matter, but still there is communication. And so I stand corrected in this notion that it's about the data and not about the code, but nonetheless, it's a different language. Mm-hmm. We have a question from Tal.
We'll make it very short, given the time. Yes.
Sure.
I just wanted to comment or raise a question. Don't you think that it's just another case of the camel who doesn't see its own hump? We blame the algorithm for discriminating between people, and we blame the algorithm for not having a due process as the one that we allegedly have. But with all due respect, our human systems, political and social systems of legislating, of promoting policy, has its own deficiencies as well. And in addition, we are talking now about the first generation of problems with algorithms, but we have another coming episode, I guess, with more deeper biases. You mentioned cognitive biases, so I think so. The next level will be how to teach the AI to avoid the biases that we have, such as loss aversion, anchoring, and etc. In any case, thank you all very much. Very interesting discussion, and I will stop.
Niva, Karni, or Yuval, for Meir, would you like to respond to Tal's point?
I can answer from our point of view, from a government regulator point of view, that first of all, nowadays we understand that evidence-based regulation is also, before AI, it's a complicated concept because we know that the status quo is not neutral, and sometimes we don't have enough evidence to make changes, and we need to make changes that are not evidence-based. So that's even before AI, and that's, as you said, part of the reason that we want to allow trials and sandboxes and other experiments in regulation. And regarding AI, I think it's going to be a huge challenge for us, and to understand, to re-understand the concept of evidence-based in the realm of AI in various sectors of the economy. Nowadays, we are considering whether the challenges are sector specific or whether we have some general challenges that we need to address. But I agree that we'll have to reconsider what does it mean to be an evidence-based regulator in an era of AI activities. So it's a huge challenge for us. And we are only in the beginning of meeting that challenge in the practical level for us.
Thank you. Niva, Karni, a brief word?
I don't think that the question is whether we should blame the algorithm or not. I just think this is not a good way of addressing the problems. The question is, where does it work for us, and how does it work, and where does it fail? And I think one of the purposes of our inquiry in our paper was to look for the Lex AI failures. Not in the sense that they are biased or discriminatory. I agree. I think that we'll learn that and overcome this. And I think that we need to learn how, what type of signal does it give us, and when does this signal is unreliable, and so that we should actually design some social intervention or policy intervention in order to make sure that it does do the work that we want it to do.
Thank you very much. So the notion of the human in the loop, on the loop, above the loop, the hybrid relationship with human and AI, I think is an excellent segue to the next panel, which Dalit will share in a moment. And Niva gave us the signal, apropos signaling effects, that our time is up. So I'd like to thank Yuval and Meir and Karni and Niva for their presentation, and switch to Dalit. Please do lead us on for the next panel.
Thank you, Amnon. May I say first that I'm honored to be the chair of this distinguished panel with such distinguished ladies. And let's start because we are out of time. In recent years, we have witnessed various attempts by countries to regulate and control the online world. Meanwhile, many countries are asking themselves, what is the right way to deal with this big tech? Some countries are trying to regulate those large companies, including the obligation to actively monitor and remove problematic content. Some states contact the big tech, as Israel did, and established a voluntary alternative enforcement route in which the state applies to companies without any court order or without any public oversight of what goes on behind the scenes. And things are taken down without us knowing anything about that. Facebook recently set up an oversight board, and on the one hand, many questions raised concerning the ability for this body appointed by Facebook to criticize the company and its policies and activities. Another criticism is that this is Facebook's maybe way of evading regulation on them. And on the other hand, some have high hopes for this new institute. Recently, a decision was delivered by the Oversight Board regarding the question of blocking former US President Trump from Facebook. And this decision, among other things, the board criticized Facebook and its blocking policy. In our panel, hopefully, we will try to understand the last decision of the Oversight Board. We will try to understand how this board is functioning and what is the proper way to regulate the big tech. We will also discuss further regulatory challenges in the field of competition law. Without any further ado, and because we are out of time, I will just hand the stage of the Zoom stage to the first speaker. First of all, we will hear all the speakers. They will have 10 to 15 minutes, and then we will open the panel for questions. And the first speaker is Amy Palmore. Amy is the former Director General of the Ministry of Justice in Israel and was the chair of several public committees concerning sensitive social, legal issues in Israeli society. Palmore is currently a lecturer at the IDC Herzliya and the IDF Leadership Program for Senior Officers. Palmore is also one of the first members of Facebook Oversight Board, and maybe you can enlighten us with the last decision. Amy, the floor is yours.
Thank you very much, and thank you for inviting me. I'm honored, and the first panel was fascinating. I'm still trying to get over the fact that I just realized that Waze is sacrificing me for the collective good of others. I dedicated my career for the collective good, but not when it comes to Waze. So I'll have to think what I do with that from now on. There is a lot to talk about, and it's going to be difficult and frustrating in 10 or 12 minutes. And maybe this is the general feeling, first, when you speak about Facebook, and second, when you speak about the Oversight Board. First of all, I think the choice of the name wasn't too bright because people most of the time are being frustrated that we are not really overseeing everything bad that Facebook is doing. And being an Israeli, and most of you know what is the mentality in Israel, I am being approached on a daily basis from people who expect me to fix Facebook on every term, and they have a difficulties to understand what is this global board, which has nothing to do with the everyday life of the Israeli user. I think that if we want to talk about the board, we have to mention first the fact that it is supposed to be an independent board. It is a different company. It was, I mean, I don't want to get into all the financing of that company, but it is a different company from Facebook. Most of us are doing other things, and we do not depend on this for our living, although we are paid. I think it's important to understand that, because I think that we spent the past year trying to figure out how do we feel about this, being suspicious ourselves about this institution, and trying to do our best in order to make sure that it will be worth the trust or the hopes of people who are using the social media platform. I have to say that for me, I'm keeping a diary ever since this was created, because it's not only a regulatory startup. I think it's a new institution, a new invention, and pioneer in many ways. And it's an interesting experience. And it was interesting for me getting prepared for this panel to read back the things that we went through in the beginning, the questions that I had to ask, the things I didn't know at all. So we spent the past year and first learning the rules of the country Facebook, you know, the community standards. I keep saying every time I talk about the oversight board that the majority of the users have no idea what are the community standards. They heard about them. They're very frustrated when they are being blocked and they're being told that they did something that breaks or that is opposed to the community standards, but they have no idea what they are. And actually Facebook never demanded them, never tested them before they gave them, it gave them a license to be on the platform and possibly to do harm. And I personally believe, and goes back to my career, that most people don't want to cause harm. And this issue of educating the users, I think, is crucial in order to really change the platform, just as it is crucial to re-educate or to oversight Facebook itself. So first, we had to learn the community standards. Second, we had to understand where we will have to meet the international human rights laws and try to understand how these things can work together. I want to say a few words as a person who has been advocating diversity among policymakers for so many years. We are 20 people. Most people talk about the fact that we are from all over the world and there is a geographical importance to our backgrounds. I think the diversity in our professions is what makes this board really interesting in terms of regulation. We are not all lawyers. If we have a former prime minister and if we have the former chief editor of The Guardian, and we have activists from around the world, and of course we have distinguished law professors, not only from the US, but also from Europe and India. If I look at myself, I think that what I bring to the board is my experience, not as a lawyer and not from my legal experience, but as a policymaker, as a person who headed tribunals in all kinds of context of my career, and person who is dedicated to protecting minorities, trying to advance justice and access to justice, and also in creating grievance mechanisms. All of these are part of what we are supposed to do. And when we try to discuss a case, and we will speak about the Trump case, which is of course the one that you think that is the most interesting, all of these issues are being expressed in those discussions. And it is different, and also trying to bridge between our different cultures and our different point of views is part of what is difficult about creating this board and trying to answer those questions that we are supposed to answer. But it is also what makes it, I think, even if there will be a formal state regulation on those big tech companies, I think the oversight board as it is has an important input in everything that Facebook is doing. We have something that Facebook doesn't have. We have the privilege of time and depth, you know, to discuss things that content moderators or AI systems have to decide within seconds. I think that when we speak about social media and regulation, I was raised in an era that there wasn't a profession of being a content moderator. If you listen to this, you know, to this description of a job, just imagine what we would think about it when we were younger. And, you know, all of us being raised in a democracy, that there are people who are being paid to be content moderators. How this is even in connection to human rights, to freedom of speech, and understanding how this is being done is part of what we are inquiring and doing in order to improve it. I think that if we have to speak about the Trump case, I will say that, again, it was a case of frustration for the public. Obviously, you know, some people thought that Mr. Trump is the problem of the world, and others think that Facebook is the problem of the world. And trying to keep everybody happy was definitely not our mission. And I think that the decision that was made, and I think that it wasn't very well explained by the press, especially not in Israel, is a decision that is not about pleasing, is about taking the time to truly analyze and try to make a difference in the long term, not in the short term. So first of all, analyzing and asking, did Facebook obey its own rules? I think this is basic. And I don't think that anyone has been challenging Facebook about this question. I mean, people keep complaining about being blocked, but they don't have the possibility of asking Facebook to be consistent, to be transparent, and even to understand, you know, if it is being done according to its own rule book. So first of all, to say that the decision on January 6th was according to the rules, but the decision of a ban, which is indefinite, was something that was invented on January 7th, and there is no law that can be invented and applied the same day, especially not when we are dealing with such fundamental rights, such as political speech. And I want to say that when we discussed that, we didn't discuss only the rights of the user named Mr. Trump and at the moment, the president of the US, but we discussed also the rights, the basic rights, which are recognized of millions of users, of millions of voters around the US who have the right to seek for a political opinion and to hear him. So realizing that on one hand, one decision was according to the Facebook rulebook and the other was not, I'm sorry if we disappointed people, but this was our first mission. After that, trying to evaluate if it was according in the sense of what was the danger, what was the community standard, how did it, when you try to analyze it according to the Rabat plan of action and try to assess the context, the status of the user, the intent, the content itself, the extent and the imminence of harm. This is something that you cannot do without posing important questions to Facebook itself. And for example, one of the questions we asked Facebook, we asked them 46 questions. They answered only 37 of them. One of the questions they refused to answer was what kind of content Facebook chooses to amplify and what was their responsibility for this. And if you notice the word I'm using the words responsibility, accountability, transparency, fairness. These are things that we are used to demand from our governments, not from a private company. And this is why I think that the discussion about this case missed the fact that this is the first time that the world is realizing, not only, of course, we have the UN guiding principle for businesses, but I'm talking about a general and deep discussion about the fact that, yes, we would like to do a lot of things to those big tech companies, but first, we can start and demand things that are relevant to their immense power. And I think that when Mark Zuckerberg, created Facebook, nobody thought, I just want to read it because I wrote it to myself. Nobody thought that Facebook could set de facto the standards of free expression around the world. And this is something that we are putting out loud for the first time. And I think that we cannot ignore the fact that this is the first institution that is able, and Facebook accepted that, is able of demanding actions from Facebook from the world of freedom of information, because we are asking them through our questions and in our policy recommendations to give us data, to analyze their own data, to give a report to the world, to users, that is dealing with the more difficult questions, because they are giving, they have an annual report and it has a lot of interesting information, but it doesn't have everything we need. I want to say again that we cannot ignore the fact that the board has only 5 Americans. It is supposed to be 40 people by the end of the process. And therefore, I think that this case, for example, had to deal with other legal questions, such as how come an American company is dealing with an American user, which is also the American president, and is not referring to the First Amendment. I mean, this is our law. Would most Americans say, and knowing the Israelis, they would think the same if it was such a case. How come 15 people who are not even US Americans, US citizens, can decide about our life and our politics and our freedom of speech? We invented freedom of speech. And I think that the other important thing that the Oversight Board is doing, that it is an American company, but it is a global company, and it's dealing with 2.5 billion users around the world. And therefore, the international human rights law should be governing the decisions and not local laws. I think this is one of the difficult challenges. And if you would read back the few decisions that we made already, we are dealing with this, with how to explain that, how to deal with local issues and try to apply them in a company that is global. I want to say something as a closing remark, which is also, of course, my personal opinion. My long-term thoughts is and about how Facebook should change, or maybe what it should be invested in, is dealing a lot with issues that you raised before, and I'll explain why. Because I think Facebook should have been more invested in education and prevention. It's really, it feels like being many times like the Dutch boy who tried to save his country, with putting his finger in the leaking dike. But Facebook would, when I think about it, should have been invested in prevention. Prevention is not only educating and it's explaining what are the community standards. And they have been doing, if you would read the Schwarze Piet decision about, it's a Dutch case, by the way. They tried to let the users in Holland to be aware of the fact that they had a new policy about blackface just before a holiday in Holland where blackface costumes are common. But preventing is also maybe thinking that instead of trying to apply AI technologies to moderate the content, just imagine a world where a user, that I still think that most of the time is innocent, could check its own content before sharing it using AI that knows how to identify difficulties. And in my world of this regulatory startup and self-regulation, the self-regulation should not be only a Facebook choice, but also the user's choice and their capability to be safe and keep the platform safe. I know my time is over, so this will be my, I just want to say we did things like that at the Ministry of Justice. And just say one word about this. We had a new legislation about online sexual harassment. And I was happy to see that one of the chief prosecutors came up to me and said, I understand that it's not going to be very simple to enforce this law on minors who are 13 and 14. It's much more important to try and avoid the harm of sharing content, which is so dangerous. And we did a big project of trying to teach and raise awareness, teach at schools, raise awareness through campaigns that we paid for. I was very proud of that. And I think this approach is a new approach, understanding that the law is not the only tool in order to regulate. There are other alternatives. Thank you.
Thank you very much, Amy, for sharing your insights and enlightening us with the facts that we might miss in your decision at the Oversight Board. It was fascinating for me. We will now move on to our next speaker, Kate Klonick. Kate Klonick is an assistant law professor at St. John's University Law School and an affiliate fellow at the Information Society Project at Yale Law School. Klonick published many articles in leading journals, leading newspapers and magazines, and her research centers on law and technology using cognitive and social psychology as a framework. Klonick has been studying and writing about private internet platforms and how they govern online speech. So without any further ado, the stage is yours.
Thank you so much for having me. Emmy, it was so wonderful to hear you and finally to meet you. I have heard wonderful things, and so that was a great, loved hearing your thoughts on this last decision. So as some of you might know, because I came to Haifa last year and had the honor of giving a talk about my research about the Oversight Board, I have been following its build out inside of Facebook for around 18 months and then leading up to basically the launch of the Oversight Board, and including Emmy, and it slowly becoming its own kind of stand up on its own two legs institution. I'm gonna really quickly share my screen to just kind of give a very kind of simple graphic that I kind of made up that I hope just shows how exactly the Oversight Board works with Facebook and the trust that funds it, because I think it's kind of not fully understood. The trust holds a $130 million, I say endowment here, but it's actually not technically an endowment, which is becoming increasingly key. It's supposed to be enough money for 6 years of the board to function, which would be 2 terms for every given board member. And it's basically an irrevocable gift that Facebook has made into this trust. And then trustees basically hold this and pay it out to an Oversight Board LLC, which is essentially kind of the administration side of the Oversight Board. And then that LLC and that administrative side supports and serves the board itself, which includes Emmy and the 20 other members. So I'm just gonna share really quickly. So I wanted to kind of to show that because it gives the bigger valence of independence and everything else that the board has come under a lot of heat for. And I think that if anything, the board is at its zenith of independence from Facebook, or on its way to being in its zenith. I think in the last 5 or 6 years, when the question of continued funding comes up, there might be some conflicts conflicts that could arise. Hopefully they won't, but that would be a moment for conflicts to rise. But I think right now it is actually a very financially independent board. And from everything I hear, and Emmy can dispute this, of course, it's a group of people who have very illustrious reputations, are really, a number of them are very outspoken against Facebook and have been even for years and years, and are really, frankly, not willing to take on the toxic reputation of being in Facebook's pocket. And if there is very little, I mean, it's a very social theory, but it is in fact really, I see where the power is kind of coming from in terms of the board maintaining its independence, is that simply this is not a group of people who are willing to simply be a solution for Mark Zuckerberg's problems and willing to carry water for Mark Zuckerberg's problems. So what I see the board and what I saw the decision for Trump with, and I have to say that, like, we've seen a number of decisions, a little over half a dozen decisions come out already before this, which were hugely significant, which were dealing with global issues, giving them transparency, giving reasoned answers, giving an analysis of rules, bringing proportionality to bear, all of these international human rights issues, all of these international human rights law issues, that this has never happened in this space before. I just don't know how to say this enough. I mean, he said that, like, when Mark Zuckerberg created this, like, no one thought that he'd be able to do free speech. I mean, in 2016, when I started writing about this, no one was thinking that this was happening. And when I was saying to people, listen, they're making up all of the rules for freedom of expression for the entire globe, and no one's going to be able to stop them. My Yale professor, famously, I told this story to Michal, like, I was like, just like failed my paper and said it wasn't a legal paper and it wasn't dealing with legal issues, and that, like, I shouldn't be writing it, which is like a very funny kind of kind of story now, but it's just, it is, I really wanted to mark that, because it was just like, this is how far away we were, and it was only 5 years ago. And so I couldn't agree more with the idea of education, the idea of making people understand that these are their rules, putting people on notice in a very formal way, like, just so that they can concretely understand the rules that they are under, giving them reasoned explanation, creating proportionality in the punishments. These are huge steps forward. And it has always been that individuals like Donald Trump, like Kim Kardashian, like like Navalny, like anyone, like, get these special treatment because they are huge figures, because they have massive followers, because they have, that they show up in Google News searches. And that is also something that if Facebook wants to decide that they're going to treat not everyone the same, that there has to be more notice and more more clarity around how those distinctions are made, how those rules are applied, and what they are. And so that, for me, was the beautiful part of the Trump decision. There were a couple of beautiful parts, but one was the fact of calling out this newsworthiness and public figure distinction, which I wrote about in a piece called Facebook v. Sullivan, which I wrote the history of basically how newsworthiness developed as an idea inside Facebook and the content moderation system, and how there was a moment of tension in 2013 after the Boston Marathon bombing, in which a picture was should have come down under the Gore standards that Facebook had, and a group of people decided, because it was an American disaster and an American issue, that it was newsworthy and had to stay up and become an exception to rules for Gore. And a number of people inside the company thought that this was inconsistent, and that you couldn't make up rules as you went along, and had been pushing for reliable rules the entire time. And a small majority, very powerful majority that included Sandberg, decided that this was going to be, newsworthiness was going to be the standard, and that was it going to be forward. And so in 2013, a bunch of people left the company that had been like the authors of most of the content moderation community standards, and this became, newsworthiness raised as its ranking, because, as you might realize, it is a completely malleable standard that answers to very little, and it can serve the company quite well from a prosecutorial standpoint. Basically, it can be anything they want it to be. And so there is a reason, a very specific history and reason around newsworthiness. And so having this come to light and having this exposure to this idea, which I've been thinking about for years and seems one of the most inequitable parts of the Facebook community standards and online expression, was tremendous. I was just so thrilled to see it put out there as an idea, just for the public education's sake. the second thing that is really fascinating about this is that it could have gone a lot of ways. And in fact, I know that Facebook was basically prepping like the possible distinction of put him back up, leave him down, put him back up with categorical rules. And this was not what they were expecting at all. This was simply not what they were expecting. And what I take this decision to be from like an administrative law, I almost take it to be an administrative law decision, which is like the equivalent of like the Social Security Administration coming to the DC Circuit and saying, hello, DC Circuit, why don't you tell us the age at which people should start receiving their Social Security benefits? And the DC Circuit saying, hell no, like you're the agency, you get out there and you take the heat and you make your Social Security age, like, and we'll tell you whether it's in keeping with the Constitution and reasonable and consistent with your other rules that you have as an agency, but we're not going to make that substantive decision for you. And so I actually think it's a beautiful framing, and it also, not to get super into American law and ad law, but it is a framing that sets up basically an agency deference question for later on, a question of how you're going to basically set up an administrative deference, an agency deference level to Facebook, and when you're going to basically be able to hold them with a backstop to international human rights law. And I think it's a beautiful, very like, I think that it actually, in terms of looking down the road and seeing what this is going to do and how you're setting up your structure for your jurisprudence into the future, that it is a decision that really threads a needle and allows for a very, very elegant outlay of decisions that are going to come down the pike. So the last thing that I'll say is that the Trump decision got a lot of press. And that was very frustrating to a lot of people, especially those that felt like there is a lot more and a lot worse things going on. People are obsessed, for good reason, with the actions of Facebook in India right now, specifically in regard to Modi. They are very concerned about Bolsonaro's use of social media in Brazil and COVID disinformation. These are enormously huge issues in countries that are just as democratic as the US, and just as large, and frankly have larger Facebook numbers, have a more prodigious like amount of people that are on Facebook. And so I think that this is, I actually strongly disagree with the idea that the board, like that it's crazy that there's only 5 US people on the board, because I'm glad that there's 5, but Facebook is no longer a company that is a US company. It is a US founded company, but it is not a US company. The US could not stop Facebook if it tried. Like if it tried to break it up entirely, like it would still continue to exist in all these other places. Like the US is only 7% of its market share. It could keep going. It would be fine. Okay. And like the same is true of the EU, the same is true of India, the same is true of South America, like everywhere. Like these are all, that is the crazy part of the power that they wield right now, is that in their transnational nature, there is not one single set of regulations that could stop them. And so I think that actually the power in this, like the power of the board, is in its transnational approach and ending some of this American exceptionalism that has haunted the community standards for years, and that continues to haunt a lot of the policy within the company. And I really am looking for, I know that they are working right now on adding people to the board, and I'm very much hoping that there are more people, specifically from India, Pakistan, and the global South generally, because I think that is a voice that is is in desperate need of an amplifying voice in this debate about global online speech. And thank you so much. I have to run because I mixed up a time thing, and I'm supposed to be speaking in London also right now at a panel on this exact topic. So I'm going to sign off, but thank you so much for having me on.
Please just wait for a minute, and maybe somebody will have a quick question for Kate.
Sure.
Does anybody wants to ask anything? Okay, if not, we will just let you go. And thank you
I'm
very much.
I'm very sorry. Thank you so much. This was wonderful.
Thank you. So now we will move to our last but not least speaker, Michal Gal. Michal Gal is a law professor and director of the Center for Law and Technology at the Faculty of Law, Haifa University. Gal is the elected president of the International Academic Society for Competition Law Scholars, and she is the author of several books, published numerous articles in leading journals, and has won prizes both for her research and her teaching. So, Michal, the stage is yours.
Thank you so much, and I'm honored to be here. Thank you for the invitation. Let me share my screen. Okay, I hope you can see it. Can you see it? Yeah?
Yes, yes.
Yeah, okay. And you can hear me well as well?
Yes.
Okay, great, great. So I'll start by saying that it took some time and a lot of academic commentary and public pressure, but we are there now. The question is no longer why regulate platforms, but rather how and who. And this this is a question that is asked not only in Europe, but slowly other jurisdictions as well, including the US, have joined the wagon in the past year or so. So how did we get here? Part of it, I mean, we all know, and this is no news for us anymore, that information is power. And we all agree at the same time that digital platforms deliver many benefits. However, we recognize that they also create costs. And some of the negative effects that they create include exploitation of vulnerabilities through price discrimination or partial information, fake news, deep fake, privacy harms, concealed data, echo chambers, attention spans, high prices, and limited choice. And this is of course not the whole list. Many times, many of these harms are blamed on the lack of competition online. And there's actually a battle of, sorry, I'm going the other way. There's actually a battle of views that is ongoing. On the one hand, there are calls for more action, for stronger enforcement, for rethinking the goals, for new regulation, for new theories of harm. But at the other end of the spectrum, there are still people that vie for a more lenient approach, thinking that these large platforms have been created based on efficiency and they are national champions. However, this group is, I would say, it has, at least in Europe, it seems like it lost at least part of the battle. And it's interesting, I think I find it interesting that it's even a battle of names. So it depends on whether you call the ones calling for more changes, you call them hipster or you call them populist. Or even how you call the big five, whether you call them the GAFAM or whether you call them the G Mafia, where the I is IBM. And regardless of where you are, what is interesting is that this battle of views has spurred new regulation. And if we only look for a moment at the EU, we can see the GDPR, the DNA, the DSA, and this is only a very, very partial list of the regulations that are now being considered or being applied. Now, there's so much that is going on now in terms of exploratory regulation that, of course, I cannot cover it all, yet let me give you some pointers. Let me, before I go to the regulation, let me give you some facts. Because one of the main concerns regarding competition, okay, focuses on concentration in some digital markets. And we're talking about the emergence of a small number of big players in digital markets, such as social media and e-commerce and search and online advertising. And many of these markets are dominated globally by one or two of the same 5 large digital companies. These are the GAFAM. And many of them, of course, as we all know, are platform markets. And it's not only the concentration, the level of concentration, but it's the sheer size of firms. Just take Facebook, which has over 2.3 billion active users. And what is also interesting is that when we look at the market shares of these firms over time, they actually are quite stable, or they even grow a bit, which means that competition is not working. Okay, so why isn't it working? The problem is that at least part of this concentration is based on the unique characteristics of database markets. So we talk about economies of scale and scope, especially in data collection. We talk about network effects for certain online services, such as social networks. We talk about barriers to entry for startups that don't have access to large data sets. We talk about what's called the paradox of free, where new entrants must compete on quality. And then we also talk about behavioral limitations, that users simply do not multi-home. They prefer the default option that they're given in many of the markets. So this creates fast-moving markets that tip towards a single winner. And as one of the UK reports has emphasized, it's the combination and the strength of these unique characteristics that I just mentioned that makes digital markets unique and makes it more difficult to enter the markets. However, at the same time, there are also what you might call man-made limitations with regard to competition that create this concentration, and they might involve anti-competitive agreements or the creation of multi-product ecosystems where you make it more difficult to enter because you have to enter many levels at the same time. It might be tying agreements, or it might be mergers that these digital platforms engage in. And it's these factors that the regulation actually wishes to tackle. And of course, we must be careful not to over-regulate as to not lose the baby with the bathwater. However, the idea is that we should allow competition where competition can solve at least some of the problems created by concentration. I should say that, in the past year, Zoom is horrible because I find myself at least once a week in a conference elsewhere around the world. So I found myself with the chief economist of Google several times, Professor Hal Varian, which is, of course, wonderful and extremely smart. But what Google says when talking about the power problems created, they talk about investment, okay? How much these GAFAM firms are investing. And they are very large spenders, as you can see. This is the revenue spent on R&D by company, and they are some of the leading companies around spenders around the world. However, I always ask, what is the benchmark? I mean, how much would other firms invest if the market wasn't so concentrated? And what exactly is the spending? Are they spending on? I mean, these are, of course, important questions that should be asked. So putting this aside, let me give you some example of what is done in competition law and in the synergetic regulation. So, of course, maybe the best solution for us with regard to digital markets might be this. But of course, this is something we won't do. So we use other tools alternatively. One thing that we do is we apply more and more cases around the world, which apply traditional competition law to the GAFAM firms. And one that I want to mention two, okay? One from the US and another one from Europe. So the one from the US, this is a really interesting case. It was brought in, October 2020. A good date for weddings, probably. Many zeros there. But anyway, this was really surprising because for many years, the US did not bring a lot of cases against monopolies, not at all. And this was a huge case and a huge change in how the US reacts. So just to give you a flavor of what is alleged here, it's alleged that Google has engaged in anti-competitive conduct. It's foreclosed competition for internet search through contracting. It used a system of carrots and sticks through contracting, becoming the default on all devices, past and present. How did it do it? It did it through agreements limiting anti-forking of Android code with Android device manufacturers. It entered into pre-installation agreements of APIs and Google Apps. It entered into revenue sharing agreements. And to look at the different defaults that you find on many phones, on Android phones, you can see that Google actually controls the whole system. So are these anti-competitive agreements? The courts will decide, but I think that they have a good case there. Another example comes from Europe, and that's a completely different one. This has to do with abuse of monopoly power. And here the allegation was that Facebook, this is a case from Germany, okay? And the allegation was that Facebook has a dominant position in the German market for social networks. And the German Competition Authority has decided that the extent to which Facebook collects and merges and uses data in user accounts constitute an abuse of the dominant position. And so what it found is that it engages in excessive data collection. Now, this went all the way to the German Supreme Court, and the Supreme Court confirmed it. They confirmed it in 2020, and then they gave a detailed decision in 2021. It's a really interesting read. And now this is in front of the ECJ, okay? So we'll say the ECJ is the European Court of Justice. So we'll see where this leads. But it's a really interesting use of competition laws, of traditional competition laws in a non-traditional ways, okay? Because we used to talk about excessive pricing, and now we're talking about excessive data collection, okay? I think that's a really interesting case. There's also, of course, a typology of many other suggested solutions, and I'll just really quickly go through some of them. I don't have time for all, but some have talked about, breakup as a remedy. We all know about Senator Warren, but it's not only she. It's the Euro parliamentarians have also suggested that that is problematic because it's not clear how it can be achieved without undermining some of the unique features of database markets that I talked about before. What is, I think, more relevant is no self-dealing. And here, India, for example, has taken this to, if you want, to the extreme. For example, Amazon. You cannot buy anything that Amazon itself sells on Amazon in India. Amazon can only sell things that other suppliers provide on its own system. And Europe is going in this direction as well with the Digital Markets Act. A lot of people are talking about blocking killer mergers, and these are mergers that simply take technology that has a potential to compete with your own system and buy it and put it on the shelf. That's why it's called killer, because you kill the technology. And then there's some behavioral solutions. Just to mention a few, there's mandated access to data. And then there's also a suggestion that I raised with Nicolas Petit, mandated access to algorithms, not only the data, but the algorithm, the learning algorithm. There are suggestions with regard to changing the definitions of market power that might not fit the digital world, stricter rules for unilateral conduct. And there are also thoughts about procedural remedies, speeding up enforcement, for example, fast-tracking competitional cases in digital markets, greater use of interim measures, maybe lowering the standard of judicial review, because full merit review on appeal might be unduly exhaustive in some cases, changing the assumptions. This is what Europe is doing. It's creating assumptions, very strong assumptions about some types of behavior, and changing the burdens of proof. Germany is doing in its competition law. And so there are many, many suggestions that are put today. And I want to finish with this, just put, these two questions there. Is the market working now? I mean, we see Google and Apple now in the tech wars. I think it's not working so well, but we can talk about it maybe later. I know I'm out of time. And then again, are we creating the best balance between privacy and competition? Another important question that I'm not sure we're getting right. Okay.
Thank you very much. And because we are out of time almost, and because I know that some of you experienced sirens during the last panel, and I hope everything is okay with you. Gadi has now a question to the panel. Gadi?
So first of all, this, maybe Michal, you can just release the screen share so we can see everybody.
Oh, sorry, of course. Let me sure.
So thank you for this extremely educating panel, and it's amazing how much new stuff people can say in the 10 minutes allotted to them. And what was very surprising is Emmy, you talked about international law being applicated regarding Facebook. And well, I'll give an initial remark. I admire people like you that are willing to put themselves on the front line of something so controversial like Facebook. So, but on the other hand, it is controversial, and what
not for the first time.
And what I fear is the tension between what I think is the legitimate will of a national legislature to talk about the freedom of speech and the speech between two members of their own society, even if it's done vis-a-vis an international platform. I would say that what you're offering is maybe dangerous to the national level, to the society and its own ability to decide what it sees as legitimate speech or not. And using international norms and standards may harm, let's say Germany sees free speech very differently than the US, and of course Israel sees it very differently. They think all our legitimate views and using some sort of international standard may harm that. So I would like your two cents about that one.
Amy, just before that, maybe because we're short of time, maybe we'll collect a few other questions and then we will just open it for answers. Amnon, you had a question too.
Very briefly, a question actually to Michal and Amy. With respect to Amy, what worries me, if I go to the heart, I mean, there are lots of wonderful things that came out from the board, And I want to echo what Kate said before about its importance, about a very meticulous and careful and considered way in which it issued its decision. But having said that, what worries me is the notion of transparency with respect to the arguments. So there's a very interesting dialogic, talk about language, dialogic aspect here between the board, Facebook itself, and the rest of the community. And here I tie in also Michal. Part of the issue of whether we have a monopoly or not is also monopoly on standards. This is not direct market power, but this is about monopoly of answers and ways to approach content moderation or privacy on other issues. So this is also an interesting regulatory perspective. So to the extent we don't really know what the arguments were for or against in a way that is accessible to us, maybe this is a point for the future so that we can review the board. We can fulfill our duty as an academic community or regulators to say to which argument did you actually address, or and to which not so much. I'll be brief here and I'll stop.
Okay, so I'll be happy to answer, or there are more questions?
No, feel free to answer. Thank you.
First of all, it's not an easy choice to join the board. This is to Gadi, and it is a lot of concern, and it bears a price. By the way, this is the moment to say, due to the Israeli reality, I've been attacked both by a BDS campaign that has been going on for an entire year, claiming that I am the person who started the cyber units in the Ministry of Justice, which is a lie, and that I've been involved in silencing the voices of Palestinians, which is a lie. And at the same time, the son of the Prime Minister has been tweeting against me constantly, including in English, that I am the new police of thoughts, America beware, this is a deep state former official, and so on and so on. Okay, so it is a difficult choice. I truly believe, and maybe I'm a little bit naive, that this is a very natural continuation of my career, trying to serve the public. This time is to serve the public of the world, and trying really to protect the weak, the underdogs, okay, against big powers or whatever that is. Your question about international human rights is a bit surprising because, first of all, so many countries have been committed to applying UN covenants and so on. And first of all, the alternative was to apply only the community standards across the world. And it is difficult. It is not attentive to different cultures. It is not attentive to different rules. And this question of how to apply those standards, the Facebook standards and the international human rights standards, when it is opposed to local issues, is something that we deal from one decision to another. And I invite you to read our decision about Zwarte Piet, which is from Holland. It is really difficult to intervene with a local tradition. It's not a religious tradition, but just imagine it would have been a tradition. And to say this is to share a video from this is forbidden on the platform. But this is decision, and read it. It's interesting to see that. Michal mentioned the free service paradox. And you asked me also about those, demands of transparency and so on. I think that the whole difficulty with trying to regulate Facebook and try to demand things from Facebook is sitting also on the basic answer. I don't know if you're aware of it, that Facebook thinks that it is giving a free service to the world. And therefore, it is not obliged to give what we call, client service, minimal obligations that we expect from a company who gives us a phone, a cell phone, or health services, and so on. So we are really trying to create something which never existed, and to try and understand. And we keep asking those questions. I mean, we don't have all the answers. I mean, every time we tackle a new question and we're trying to understand how it can be applied and how can it live with the whole concept of this platform, of the idea of social media, different cultures, and so on. And it can't be answered here. We don't have the time, and it's worth another discussion. So I hope we will have the opportunity to have it.
Michal?
Yeah, I think it was more of a comment, and it's a great comment, and I completely agree that this is one of the types of market power that can be created. Again, the idea behind competition law is that if you have competition in standards as well. But when you have concentration, of course, that creates the power to create standards as well. So thank you. This is a great comment.
I just want to add something about Kate's comment about newsworthiness, just in order to make you think about this. You know, this newsworthiness exemption is something that Facebook declared on the Trump case that it was never applied. Do we believe that? I mean, is it even, you know? So the fact that they have to start and be more transparent and answer questions from someone, even if it's not enough. And I think Meir Levin said, you know, there's never a vacuum, but there was a vacuum with Facebook. And so we didn't fill the entire vacuum, but we are starting to make a little difference, a very small one, as I said, like the Dutch child with his finger. But if the academia will follow us and criticize us, I think it will empower our decisions, even if you don't like them, because the expectations that you can raise to the board is something that will, at the end of the day, be expectations that will affect Facebook and the way it behaves.
With this last comment, I think that we can just finish the day. We are out of time. Thank you very much for all of you staying with us. And thank you for the participants on the different panels. And thank you very much for the organizers, Amnon and Yuval, and especially Tal Mimran and Lily Fay-Bishor for having us all together. Tomorrow, there is a new day and a new panels, and hopefully we are looking forward to seeing you all there. So have a good night, quiet night, and see you tomorrow.
Thank you very much, Dalit. On behalf of Yuval Shani and myself, we want to also thank you and see you everybody tomorrow, 6 o'clock Israeli time for 2 very interesting panels. Bye.